Okay, I hope everyone can hear me, and thank you for sticking with us. I had a couple of things I was going to talk about. We have, to a certain extent, been overtaken by events, because as you're probably aware, there's been a massive deluge of releases in this area over the last 24 hours, both on self-employment and also further information on furlough. I'm going to cut to the chase and really talk about furlough, and that's it. Before I do so, though, I just wanted to flag up a couple of issues that have been raised in the comments, which I attempted to answer and I think revealed gaps in my own knowledge. One is a question about how do we interpret the reference in the site operating procedure to non-essential physical work, and I think that's something that we need to think about. Clearly, the issue of what is essential work, what is not essential work, at the macro level, is not relevant at the moment to the question of whether sites close or open. It's the site operating procedure. But at the micro level, in terms of specific activities and whether specific employees should do some work or not, I think that's something we need to come back to on. The other area where my ignorance revealed itself was on the area of directors' dividends. Reading the guidance that came out overnight, on the face of it, directors who pay themselves in a combination of PAYE wages and dividends, the guidance seems to suggest that it's only the PAYE earnings that can be taken into account for furlough purposes. The directors effectively furlough themselves. There were some sort of technical questions that were raised about that. I'm not competent to answer those, but we do have tax experts that we can consult, and so we will endeavour to get a steer from them. So as I said, I'm just going to skip through the things I was going to talk about, and you'll be familiar with these sorts of photographs. Just on that, in terms of the employment issues around employees refusing to work, I would just piggyback off what Rob and Ruth have been saying. Your guide, the cornerstone of your assessment, has to be, what is safe, and you base that on the site operating procedures. You base that on the Public Health England guidance, and as Rob has suggested, you give yourself a bit more insurance in terms of getting the main contractor or the client to confirm to you that they are satisfied that their site meets those requirements. In those circumstances, providing that you are satisfied, then you can give a reasonable instruction to your employees to continue working. One other question that was asked was, my employees are refusing to work and insisting on furlough. Employees, from a legal point of view, in terms of the rules are concerned, cannot insist on furlough. Furlough is the designation of employees on furlough is a matter for the employer, or they do have to agree it with the employee, but there is no such thing as a right to furlough. Now, that's the technical answer. I fully appreciate in terms of the human aspect, employee relations, it's a different question. But that's something which we will endeavour to advise you on further. I'm sorry that some of you are getting an echo. Not all of you are getting an echo. I hope overall it's okay. I'm sure Volterman will tell me if there's a broader problem. But I'll press on. There will be a recording. That question, there will be a recording, and so if you can't hear at the moment, then please, you can get the recording in due course. So really just forgetting about the JIB for a moment, and moving on to the fundamental question of what does the latest guidance on furlough tell us. Well, it was published overnight. I'm going to assume that you have a knowledge of furlough. That's basically you send employees home. There is a grant from the government that can pay up to 80% of the pay, or that can pay 80% of their regular pay up to a maximum of £2,500. There is the option to top up. by the employer, but it's only an option. It's not a requirement. And the other important thing, which I've already mentioned, is the need for the employee agreement to go on furlough. Is the furlough grant to be repaid? Well, you as an employer have to pay up front, and then you claim the furlough grant from the government. It's important, therefore, to know what it is you're going to get paid back from the government, which is the $60 million question, and I'll come to that. In terms of what we've got coming back in this detailed guidance, and this picks up on some of the comments we're getting on the feed, the government have reiterated, they have explicitly said that someone in furlough cannot perform work. They have confirmed, therefore, that you cannot operate reduced hours working arrangements and have the protection of the furlough grant under the job recognition scheme. Clearly, that's not a satisfactory situation for many of us, and we will continue to be doing what we have been lobbying for all this time, which is that should be included, but that's not included at the moment. So that does leave you with various options if you're sort of looking to operate some sort of reduced hours arrangement. Then you could pay your employees for their full working hours and either take the hit or charge your customers more. Whether that's viable or not, I'll leave it to you to determine. You could agree reduced hours and pay with your employees, even a 0 hours contract. That's going to be more problematic if you operate according to the JIB, but that is something where you could seek agreement. You could, of course, stop the business. You could withdraw that limited cover and simply furlough everybody. One question that was asked in the comments early on is whether you can get individuals to volunteer to carry on the work. And the example that was given, the scenario that was offered, was we'll get them to volunteer to work for our clients, but we will not charge. We will not charge clients for that. I've looked at the guidance, and certainly it does say that employees can do volunteer work, but it also adds employees can take part in volunteer work as long as it does not provide services to or generate revenue for or on behalf of your organization. We'll need to sort of interpret that a bit more, but it does potentially, I think, open up the possibility that the guidance is saying that in the scenario that I was described, that would not be permitted, and for the individuals to continue operating under furlough, because it's suggesting that this voluntary arrangement is on behalf of your business, even if your business receives no money. I have to say I've been racking my brains in terms of options. The only one I can think of, other than some of the others that I've mentioned already, but which might be feasible for some of you, is you don't deliver it direct. You effectively subcontract it. Subcontract that kind of work to a self-employed person. And the reason I say that, and I'll come on to that in due course, under the separate set of self-employment arrangements that have been announced in the last 24 hours, the self-employed are allowed to continue operating, are allowed to continue working at the same time as claiming under the self-employment income protection scheme. That's an option for you to consider. I would say it's not a particularly desirable option, but it is an option to consider. Another exception to the rule set out in the guidance that employees should be sitting at home and doing nothing else is that employees can go on to training, but if they are undertaking work-related training, it appears that you should be paying them at least the relevant rate under the national living wage or the national minimum wage for that training time. And that payment would be on top of any payment they get by virtue of the 80% you're paying them with regard to furlough. Um, I don't know why I've moved the slide there. I'm just moving on to the next question. Okay, the next, I mean, the crucial issue for us, and it's identified there, is what is the amount of money that you base the 80% on. Well, the guidance that we got overnight is helpful to a certain extent and not helpful in other respects. One thing new that the guidance does say is that that included in the government grant will be recompense for paying employer national insurance contributions and minimum auto-enrolment pension contributions. So you too should be operating in accordance with that. That effectively brings up the value, the potential maximum value of the grant up to £2,804, which I think is an interesting new point. In terms of the calculation itself, I'm afraid to say I find the guidance so far confusing. And we are going to have to look into that some more. Please bear in mind that we've only had a few hours to digest this. But effectively, there are two methods that they identify for calculating the sum on which you base the 80%. They talk about regular wage. Now, I think we'd better interpret that as being the same as your basic wage, your basic earnings for your basic hours, such as in the JIB, the 37.5 hours. But it's not clear that that's what's meant. The other method that's mentioned in the guidance is an average earnings method where pay varies. Now, those of us who are familiar with fixed pay and variable pay in other parts of employment law are familiar with the government distinguishing between fixed pay and variable pay, where the variable pay is linked to things like measured work, like price work or something like that, and also seasonality, people who work sort of seasonal in seasonal patterns. At the moment, the guidance isn't specific about what they mean by variable pay. So I think there's a chance, albeit I think there's a remote chance, that there could be an argument with somebody saying, well, I work overtime and the amount of overtime I work fluctuates. I would say the safest bet at the moment, and I appreciate it is not satisfactory, but the safest bet at the moment, unless you are operating people with something like price work, where you'll be familiar with averaging, the safest bet at the moment really is to assume that the regular wage calculation is equivalent to basic earnings, basically, and basically to think in terms of what's the guaranteed week, what's the basic rate for that guaranteed week, and what's 80% of that. There's a hell of a lot more detail. You can look at the guidance. We have sent out an e-bulletin, I believe, or will soon do so, which will be which will give you a link to the guidance. There's a lot of guidance about how you operate this from a payroll point of view. One thing to mention, which came through on a webinar that I was listening to earlier today, was a guy on the Treasury who talked in terms of rotating employees. There was a specific question that was asked about rotating employees on furlough. Now, as somebody's already noted on the comments on the side, the minimum period for furlough in the guidance is defined as being 3 weeks. What the guy from the Treasury did indicate, though, is that providing you stick to that, there isn't an issue necessarily in rotating people basically 3 weeks in, 3 weeks on, 3 weeks off. Now, I'm sure you would agree with me that in the kind of industry that we work in, 1 week on, 1 week off would make a lot more sense, particularly as we don't know how long these arrangements are going to last for, although the indication from the government, of course, it will last until at least the end of May. And so we, I think, have to base our own plans on that. But it did indicate a level of flexibility that's not clear from the written guidance, but we will be seeking further clarification on that. And that is something for you to consider. One other area on flexibility, the guidance does say that people on sick pay, because they're on sick leave or they're self-isolating, they're on statutory sick pay, they continue on sick pay for the duration of that time, but then when they come off that, they can then be transferred onto furlough. Interestingly, the guidance also indicates that where an employee is absent because they are being shielded, because they are at special risk, they can go onto furlough straight away. So they can be furloughed straight away, which is interesting. Okay, my final point is in terms of the self-employed. I'll be fairly brief on that. The self-employment income support scheme, also announced yesterday by the Chancellor. It's basically broadly equivalent. It talks in terms of a grant that the self-employed will be able to receive based on 80% of their average profits up to £2,500. Qualifying conditions for that grant. Most of your income needs to be coming from self-employment. For those who sort of switch between PAYE and self-employment, it has to be the main source of income rather than just a top-up. It's limited to those with annual profits of 50 grand or less from self-employment. So those earning major money through self-employment will not be able to benefit at all, it seems. And you must also have submitted a 2019 self-employment tax return. Interestingly, that the government are saying if you haven't submitted your 2019 self-employed tax return, then you've got 4 additional weeks to do. That might be linked to the fact that there is going to be a significant delay in actually making payments under the self-employed scheme, whereas payments under the job retention scheme are forecast to start being made to employers to reimburse them at the end of April. Payments under the self-employment arrangement will only start to be paid at the end in early June, and firms are advised to seek one of these business interruption loans if that's going to cause them some hardship. Final point, and I've already mentioned the point, this guidance indicates on the self-employed that the self-employed can continue to operate even though they are looking to claim under the income protection scheme. So in terms of an insight into how this mismatch between the job retention scheme and the self-employment scheme has arisen, again, the guy from the Treasury that I was listening to this morning indicated that it's 2 different teams operating, one covering self-employment, one covering direct employment. So I think, again, in terms of lobbying around that, that's a point that we can make in terms of the inconsistency between the 2 arrangements. Just looking ahead, I appreciate that this is a lot for you to take in a limited amount of time. For those of you who've received the e-bulletin, there is the link to the guidance. I do recommend that you look at that HMRC guidance. We will be producing written guidance ourselves, which will be up on the ECA website as soon as we can. I would hope by later today, if not later today, then first thing Monday. But as you appreciate, we are running to stand still on this one. I appreciate there's probably been lots and lots of questions coming through whilst I've been talking, but I'll leave it to Mike to sort of filter those, and hopefully I can answer some of them.
Great, thanks, Andrew. Yeah, I'll just read out in full some of the questions we've received and the name of those asking, and I'll pick up yours first, then we'll move on to Ruth and Rob's if we have some time. So let me read out a couple now to you. So this is from John Hughes 1. How is the furlough procedure done for small business directors?
Okay. Basically, as I understand it, if you're a small business director who is paid partly through PAYE and partly through dividends, then you are able effectively to furlough yourself, but in terms of calculating your entitlement and to calculate the 80% figure, that should be based on the PAYE earnings, not including the dividend. Now, that's one of the things I've alluded to in response to some of the comments, which people are querying and pointing out that dividend income is declared for certain income tax purposes. That's where my own knowledge ends, and I suspect there are people on the call with greater knowledge of this than I have. We do have access to specialist tax advice from Liz Bridge, and we will be seeking that, unless, of course, one of my colleagues happens to have knowledge of this area. But I suspect we might need to go to a specialist for the detail. It sounds harsh to me. It does sound harsh to me, but that is the steer that the guidance is indicating, and it was reiterated, I have to say, in the webinar that I attended earlier today with the Treasury representative there.
Okay, thanks, Andrew. Next one from Chris Smith 1. An ex-employee who has recently just gone self-employed has spoken to HMRC, and they have advised he can approach the previous employer and be furloughed. I understand Martin Lewis backed this up. Is this option correct? And we have 2 to 3 previous employees that have just left to go self-employed.
Okay. There is a detailed guidance on this with the HMRC, and if you just bear with me, I will find it. Yeah, I mean, basically, what the guidance that we have got says is that if you have made employees redundant since the 28th of February, so it's kind of suggesting that the redundancy is related to the current crisis. If they have left after the 28th of February, you can rehire them and put them on furlough. Similarly, if you put employees on unpaid leave since the 28th of February, then likewise you can transfer them off unpaid leave and transfer them onto furlough. That's what the guidance says. The key thing seems to be the date, and what happened after that date in terms of what choices they might have made after that is less relevant. It's the issue of did they leave and when was the date?
Okay, thanks, Andrew. One from John Jones. Can I employ a self-employed electrician while furloughing a PAYE electrician?
I agree it's not desirable, but and the employee relations aspects aren't desirable. But as things stand, and we will give more thought to this, but as things stand, in terms of the restriction on you from operating reduced hours and not being allowed for those purposes to have the protection of the furlough scheme, leaves you with the choices I described. I mean, one choice could be to agree a reduced hours arrangement with your employees as a matter of contract. and to operate on that basis and to pay them on that basis. As I said, you would need to think about that very carefully, particularly with regard to JIB requirements if you are a JIB company. One other option, legally speaking, is the option I suggested, which is to subcontract. It's entirely undesirable, and I have to say, from a policy point of view, and I said this in the last webinar, I think it's leading to perverse incentives, and we'll continue to make that point. But in the meantime, it has to be an option that you need to consider.
Okay, thanks, Andrew. This is from Midlands Electrical Specialists, although others have asked similar questions as well. Do we pay tax and national insurance and pension on the 80% received?
Yeah, you pay. Again, I'm starting to stray into territory that I'm a bit shaky on. The health warning is, I would say, look at the HMRC guidance. I'm not a payroll specialist, I'm not a tax specialist, but as I understand it, the payments are taxed. They are subject to employer national insurance contributions. You should be continuing to make the auto-enrollment pension contributions, and the grant that you get at the end of the day from HMRC will reflect that. As I said, the potential value of that grant, once those other things are taken into account, has actually grown to £2,804 rather than the £2,500 as a maximum. Hopefully that answers the question. One other thing that I haven't mentioned, but which again came through on the very strongly on the webinar that I attended with the Treasury, is that all employment law rights continue whilst people are on furlough. So, for example, holiday entitlement will continue to accrue during furlough. It's not suspended during furlough. That's another important piece of information, which I have to say isn't included at the moment in the HMRC guidance.
Okay, thanks, Andrew. Just one final question for you then. I'll just take a couple of quick ones for Ruth and Rob. Kevin Snowden asked for an update about wage negotiations, whether there was any connection or impact resulting from this.
Clearly there's impact. I think what I can say is that we're in a situation where a number of different agreements are up for review at the moment, and I can confirm that, to my knowledge, pretty much all the employer groups involved in those negotiations have either asked the trade union for a suspension or are considering doing so.
Thanks to all our presenters, particularly to Ruth for being our special guest today, Ruth Wilkinson from Clark's Legal. That's much appreciated. We'll be back on Tuesday at 11 a.m. for our next webinar. Rob and Andrew will both be around for that with our special guest, Stuart Young from the Department of Business, Energy and Industrial Strategy. Thanks again for listening. If you want to find out more, please visit www.eca.co.uk/coronavirus. Thank you.